All right, welcome back, outdoor industry law students. This is video 3 of session 3, and we're going to be looking at liability related to the use of products and products liability. So let me share my screen and we can get into that. Okay, products liability from current slide comes about in one of two ways. That's a picture of the, click on that, that's a picture of the Pinto exploding. I tried it a minute ago in this recording and I couldn't get it to shut off. So in any event, it happens in one of two ways. One is warranties, that is that the product does not comply with the warranties as set forth in the terms and conditions of sale. The other is that there is some injury to person or property as a result of the product being unreasonably dangerous, and that's in strict liability and tort. So let's look at these two different theories. First of all, what's a warranty? It's a contract claim, right? It's an obligation of the seller concerning the quality or characteristics of the goods. One warranty that goes with every sale is a warranty of title, that you as the seller own it and that no one else has a claim to it. So that the only way that would not apply to a particular sale, and a lot of this applies to leases too, of property, is if you purchased it at for instance, a public trustee's sale where you were buying foreclosed property, real property. Right there in the notices, it indicates that this property, the lien you may be buying may not be a first lien. There may be second liens. So if there's some type of or an auction that indicates that there could be other claims of ownership, like you bought at a sheriff's sale or something like that. So other than that, goods you warrant the merchant, and these apply to merchant sellers. And by the way, that the merchant had as title to the property. Express warranty is just like it sounds. It's one that's expressed. It's an affirmation of fact or promise. It also can come in the form of providing a sample. A sample is an express warranty that the product's going to conform with the sample that you've provided to the buyer. Implied warranties, those are warranties that are implied in the relationship with the buyer, even though you didn't state it in the terms and conditions. So contractual, you can read the screen. The two types of warranties I want to go through, implied warranties I want to talk mainly about here, is implied warranty of merchantability. Again, this applies to a merchant seller, and it's a warranty that the goods are reasonably fit for the ordinary purpose for which they are manufactured or sold. In other words, they pass without objection in the trade under the contract description and are fair and average quality. So they are fit for the purpose for which they are purchased. Now, so let's just stick with the implied warranty of merchantability. Oftentimes you'll draft terms and conditions of the sale of your products, say from the manufacturer to the distributor or wholesaler, or even the consumer, that you want the goods to only comply with the specifications. In other words, you put in your terms and conditions that here's our express warranty that these goods meet these specifications, nothing else. And so you'd be in a position where you would want to disclaim this warranty of merchantability. Let me get to that right here. If you want to disclaim the warranty of merchantability, you can see in bullet point 3 there, the disclaimer has to mention that in the terms and conditions that the merchant seller is disclaiming the warranty of merchantability, and it has to be conspicuous. It has to be in big big writing and so forth. So implied warranty of merchantability is going to be in there unless disclaimed. Implied warranty of fitness for a particular purpose. This is a big one in the outdoor industry, as you can imagine. Let's just read it for a minute. A warranty by any seller that goods are reasonably fit for a particular purpose, if at the time of contracting the seller had reason to know the buyer's particular purpose and that the buyer was relying on the seller's skill and judgment to furnish suitable goods. So this is when the person comes to you and says, I want to buy, here's my skill level and this is what I would like to buy. What do you think is the best product for my particular activity? I'm sure you all get into that all the time. That's part of what makes you so valuable and wonderful. So when a party is relying on your expertise, then there's an implied warranty that product is going to be fit for the purpose that you discussed. So just be aware that is a warranty that will be implied into the transaction unless it's properly disclaimed. You can disclaim the warranty of fitness for a particular purpose. It again has to be in writing. You need to mention it, and it needs to be conspicuous. There is some law, and the book references it. It's that has to do with consumer protections. That these type of releases are not, these disclaimers may not be enforceable when both parties don't have equal bargaining power and the ability to, review the terms and conditions before purchase and all that sort of thing. So, but they're still valuable to put into your documents, the disclaimer. However, as it relates to the consumer, it may or may not be enforceable, determining on if the get the bargaining power of the two parties and that sort of thing. Certainly between merchant buyers and sellers, you want to negotiate that sort of thing. So again, defer to your counsel on that discussion about those disclaimers. You can also disclaim the warranties by simply putting language in as is, with all faults, that sort of thing. Won't get into course of dealing, and the one that does apply as well, if a warranty claim is brought for a injury or damage from a defective product that the consumer or the buyer should have seen had they done an inspection, and you give them an opportunity to inspect, then arguably then those warranties could be disclaimed. Let's say you sell somebody a jacket and inadvertently it's missing a sleeve, and somebody's ends up with frostbite on their arm. Well, not only might that be assumption of the risk of a knowing defect, but it would be if there was a claim for breach of warranty, and associated damages, you could argue that a reasonable inspection would have shown that. You'd still probably owe the person their money back, right? Okay. Again, they must be, the courts are reluctant to enforce those disclaimers where the consumer has no effective bargaining power and really can't negotiate the terms of the agreement. So just recognize that those warranties may be in the relationship, in the transaction. All right, obstacles to warranty action. In other words, how can you mitigate claims for warranties? One, we talked about disclaimers in your terms and conditions, especially as it relates, again, to you with other merchant buyers or sellers. In your terms and conditions, you want to put language that limits, let's say you're a seller, you want to limit the liability for a product that doesn't conform to a warranty to purchase price. If you can get away with it, if that's the deal you can negotiate. And you may limit the remedies, that the only remedy is return of the defective product and then replacement. So you want to really work with your counsel to come up with terms and conditions that can limit warranty actions. there's some, you've probably seen these in many terms and conditions that we never read when we click and accept, right? Where we have given up our right to join class actions to enforce a breach of contract. And it's like, if you can't join a class action, then what are you individually going to sue a huge company? And the answer would be no. So it's got to, so recognize that may be, or that you have to have an arbitration as well. That could be an obstacle to a claim for warranty. Another, as we talked about before, is that if the contract is unconscionable, in other words, the parties don't have bargaining power and can't negotiate the terms, then the disclaimers may be ineffective. A buyer is obligated to give notice of a breach within a reasonable time. There's been some under the Magnuson-Moss Act, which also limits effectiveness of certain disclaimer of warranties in consumer transactions being household transactions for household goods, that there may or may not be an obligation to notify a breach. But just recognize, if you are companies ever sued for a breach of warranty, you want to see if you were given notice. Contributory negligence, we talked about that before. That's where the one party is the least bit negligent. That's not going to be a defense to a claim for breach of warranty. Comparative negligence may be. We talked about comparative and pure comparative negligence by the plaintiff. Voluntary assumption of risk, again, that's a contract. Is defense express or implied consent to the danger. In other words, they knowingly use a dangerous product, not that they knowingly are going to use the the crampon for climbing, which might be a dangerous activity, but that they know that the thing is obviously defective and still use it. And again, that there's been some discussion in the Magnuson-Moss Act that has to be an express contract assumption rather than simply implied through the conduct of the parties. So be aware of that. So there you have the discussion on warranties. So again, what we're talking about is where the products don't conform to either express warranties or implied warranties, and then attempts by the merchant seller to disclaim some of those warranties. Okay, strict liability and tort. This is, let's just read it, imposes tort liability on manufacturers, distributors, and retail merchant sellers, again, for both personal injuries and property damage for selling a product in a defective condition, unreasonably dangerous to the user or consumer. One engaged in the business of selling products who sells a defective product is subject to liability for harm to persons or property caused by a defect. Sorry for rereading that, but I have to get my head on straight. So really what we're talking about here is a merchant seller sells a product in a defective condition that renders it unreasonably dangerous, and the consumer is harmed. So unreasonably dangerous, that it contains a danger beyond that which would be contemplated by the ordinary consumer. Arguably, what is it, rum 150 or cigarettes or chainsaws, those are obviously dangerous, or could be. I don't know about the rum, but if you drank too much of it, or it was at 151, they're not unreasonably dangerous because the buyer knows that they're dangerous. Cigarettes, chainsaws, that sort of thing. So, but what we're talking about when we're talking about unreasonably dangerous is it contains a danger beyond what would be normally contemplated by the consumer. There's 3 ways that a product is defective. So this isn't as complicated as I've made it. 3 ways that a product is defective under strict liability and tort. 1 is a manufacturing defect, 1 is a design defect, and 1 is a failure to warn. So looking first at manufacturing defect, that means that it meets its own specifications, but it's been improperly made. An example I used, again, this is outside of the outdoor industry law, but deals with the Takata airbags, right? It's been said that they've have too much explosive whatever it is charge in the bag that causes part of the dashboard and everything to blow up in your face. So while it may meet its manufacturing requirements, that is a defective manufacture. There's too much explosive device in the airbag. You guys can probably think of some good examples in the outdoor industry where you might have a manufacturing defect. The other is a design defect, and this is where it's designed in an improper, in an unreasonably dangerous condition. So the Pinto case, where the gas tank was in the back and it was getting hit and exploded. Again, the design was defective. So if you can come up with some examples in the outdoor industry of a product where the design is defective, that would be and it causes a injury to person or property, that would be a claim for under products liability and tort. Failure to warn. This is one that will definitely affect you in the outdoor industry. And that's why we get, when you buy your prescription at the drugstore, you get a thing of warnings that you're going to grow a third eye or what have you, because of this obligation that merchants, sellers have to warn about the dangers and uses of the product. So I'm sure that you all, in your terms and conditions of sale, identify various warnings that could need to be put on your goods and services documentation. You've all seen it on a lawnmower. It shows some symbol on there, don't put your foot under there. So again, warning about foreseeable risks posed by use of the product. So that's a tough one in the outdoor industry, because you're selling products oftentimes that are going to be give the person an opportunity to take a risk, and that's what they are buying it for. So it's a balancing act in terms of how much warning you need to give them about instructions or warning. I think we have a case in the book on failure to warn, and it has to do, I know, it's whether having to do with the life jackets. And let's see, what case was that? That was Straw. No, that's bear with me a minute. Hold on one second. Escape. I'm going to pause for just a moment if I can figure out how I stop share. And I'm just going to pause. All right, I'm back. I found the case that I was wanting to talk about. It is the Wheeler case on page 73. And in that case, the plaintiff alleges that the life jacket was defective in its manufacture. It wasn't thick enough and that sort of thing. The court upheld the summary judgment against the plaintiff on that claim. You can look why that there's no indication it was defectively manufactured. But then the other claim was that excuse me, I want to get my slides back up, that the product was defective because of a failure to warn, and the warning on the bear with me here. The warning on the life jacket basically indicated that it wasn't a Coast Guard approved, U.S. Coast Guard approved life jacket and that sort of thing. And then in one spot, it says the buoyancy distribution is not sufficient to float a person face up in the water. And the question then becomes a question of fact that the plaintiff understood that to mean that the vest would not float a person face up such that he could continue to breathe even if unconscious, but that he would float at least face down. In this case, the person didn't float at all. So the court actually, on that portion of the summary judgment, said that's up to the jury to determine whether that warning was sufficient to put the plaintiff on notice that the person may not float, because it does indicate that it would not, buoyancy distribution not sufficient for a person to float face up, but it float period it doesn't seem to address, other than some of these statements that it's not Coast Guard approved. So take a look at that case. It's a good case to look at on products liability in the outdoor industry. So failure to warn, it doesn't matter. I think I made this pretty clear, if not, that on a products liability claim, the manufacturer, the distributor, and the retailer are all liable to the person that's injured. So it doesn't matter that the person that's injured has no contract with the manufacturer. That's what we call privity of contract. That is not a defense. All parties in the distribution chain are liable. Now, they, in their own terms and conditions, can try to push that liability off on the other, but as it relates to the person that is injured, they all are liable. All right, I went through comparative and contributory negligence, voluntary assumption of risk, a misuse or abuse of the product. If you're sued and you can prove that the person was misusing the carabiners, for instance, had the side that opens attached inappropriately to the harness, and that caused him or her to release from the harness for repelling purposes, then you would have a defense that there might be a misuse or abuse of the product. Again, it goes, are they warned about that type of issue with the product? So that would be one to look at. All right, I'm going to go into the slideshow again. Current slide. All right, so limitation on damages. Many states have a limitation on there's something going on here, limitation on the amount of damages that a party can recover. Certainly punitive damages. Punitive damages are those damages that are available to punish the party for willful or wanton conduct or intentional conduct, and there are limitations. And many states have limitations of liability on for compensatory damages as well. Okay, let's see what else. I'm just going to go back to share. I don't know what's going on here. Okay, this is a whole, you can click on this hot link and you'll have a bunch of different attorneys and people talking about famous products liability cases. So that's the end of this particular video. I would like you to look at the assignment that we deal with as it relates to identifying potential claims for torts or claims for breach of warranty that may be foreseeable in your business. All right.